Yeah, yeah. Yes, yes. Okay. So this scheme is applicable for all the companies, but it is only for annual filing forms. So it applies for, as I said, MGT 7, AOC 4, ADT 1, and FC 3 and FC 4, which are applicable to foreign companies. Yeah, yeah. It is available. No, no, no. Yeah, yeah, yeah. Yes. Yeah. So there can be multiple. There can be two ways possible. One way is that everything was prepared but not filed. Correct. So I think, if I'm not wrong, ICAI has made an appeal to allow UDINs for all these non-compliances, right? Old filings. Yeah, 60 days is the norm, but because of this CCFS coming in, I think there is some request made for relaxation on UDIN requirement, is what I understand. So if I'm not, I've heard it. I'm not sure if it has really happened, but if it comes through, that will solve the problem. If not, if UDIN related aspect is not addressed, then if suppose no, 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 no. Are you allowed to sign it? No, answer is no, right? So if suppose AGM has not been held and therefore no filings has been done since 2021, then you will have to ensure that you are doing all of that today in today's date and filing it thereafter. So yeah, so that is an important point. So while this scheme is allowing you for relaxation, limited relaxation on annual filings, this is not protecting you for any other default. So if in the example that we are talking about, AGM was not held, that is again a default. So that default will continue, that default will be tried as per the procedures applicable. There is no relief on those activities. Relief is only for filing. Yeah. Yeah. Yeah, so unfortunately that is the situation. Correct. No, he is referring to the inspection of documents and asking money for inspection. They are only, I think, they are not selling the document otherwise as well, but they are giving you access, they are charging you for the system access. But that has been the case always, right? So even earlier, before MCA 21 came in, for yeah. But fees is very minimal, I think, 50, 100 rupees per company. Yeah, yeah. In 100 rupees you can download in everything. Okay. But I don't have an answer to that. That is an unofficial way available. So otherwise what will happen? That action will anyways be initiated by ROC, but they will initiate at their own will, right? So whenever they will scrutinize, whenever they will take up such cases, is when they will initiate such actions. No, no, no. Okay, so in that case, I'm not sure if they will really accept the request also, because they are also bound by 248, which gives the conditions when strike off is possible, either side. Yes, sir. Correct. Yeah, yeah, it will accept. So even if, so technically speaking, as we have discussed about that example, that AGMs of 24, 21, 22, 23, 24 years have not been done. Now you complete the accounts, you hold AGMs for all these years now, your trigger of 30 days filing will begin after that. But then, see, if that is the case, then this scheme is not of relevance to you. Why? Because your additional fee will start counting from the date of AGM. Huh. So that is why. So there are two possibilities. I'm not sure if ICAI has anything is happening on this UDIN thing, but you take an example. If you do the annual general meeting today, you will be defaulted under section 96, which talks about holding of annual general meetings. But for all the previous years, you can't go back in previous years and do the AGMs. You have to do it in today's date, okay, in normal course. And if you are doing it today, your obligation of filing begins from today, 30 days, right? Correct. That is anyways possible. So that becomes that remains as an anomaly actually. How companies are going to, so practically what will happen is companies will assume that everything was done, keeping the UDIN related issue as it is, and then take benefit of this scheme. Otherwise, there will be some challenges in even taking benefit of this scheme. Yeah. Yes. Yeah. Correct. So answer is clearly no. So we have to mention no. And that's where I said that if you are holding AGM today for a previous year, it will be a default under 96, punishable under section 99 of the Companies Act. So that will, and this scheme very specifically speaks about that and says that this benefit of this scheme will not give immunity for any other non-compliances of Companies Act, which are connected non-compliances. I think it is also converted into penalty now, so subject to adjudication. So, okay, so just because it may be relevant for the group here, all of us must have heard about decriminalization of offences under Companies Act, right? What does this mean, and how has this impacted under company law? So, any offence under Companies Act, any violation of Companies Act was a criminal offence earlier. What do you mean by criminal offence? Means an offence which will be tried under CRPC. Now, CRPC talks about when we are passing an order, when the judge is fixing the liability, criminal offences are considered to be the severe offences, punishable with senior punishments, and therefore, judge will need to be sure beyond reasonable doubt that the person has committed a default. When we look at CPC, Civil Procedural Code, it is preponderance of probabilities, that probability of company making a default is bigger than the probability of it not making a default, then the offense is fixed. Now, for example, under Companies Act, most of the defaults are like MGT 7 is filed or not. Do you need that beyond reasonable doubt confirmation for that? No. That's why various procedural matters under Companies Act have been decriminalized. They will be tried under CPC now, and therefore adjudication mechanism is brought in. Adjudication mechanism under 455, earlier this adjudication mechanism was not there under Companies Act. Everything was criminal. ROC will initiate action, ROC will investigate, and after investigation, ROC will file a case with the court issues summons, and then the procedure will on go. Because these were criminal matters, there was also possibility of compounding of offences for the matters which are compoundable. What are the matters which are compoundable? Matters where there is no mandatory element of imprisonment. So offences which are punishable with fine or imprisonment or both were compoundable. The moment under this decriminalization, the term fine in any penal clause has been replaced with the term penalty. What happens because of this is, now this defaults, like not filing of annual return, not holding AGM, the penal clause now talks about the directors and company punishable with a penalty. The moment an offense is punishable with penalty, it is a subject matter of adjudication mechanism by the ROC and not the court, and therefore, because it is punishable with penalty and not fine, this also doesn't remain as a compoundable offense. So there is no compounding of offenses that is possible in these cases where the term has been changed from fine to penalty. So that is the consequence of this decriminalization of offenses under Companies Act. So on all these defaults, there is no alternative but for ROC to issue notices and impose penalties for defaults under the Companies Act. So that is the situation. So that's how earlier it was very common, and I have seen, why I'm talking about is I have seen some law firms also taking a view that we have conducted this due diligence, these are the defaults identified, companies are told to go and get this compounded. They have not recognized the difference that not all offenses are compounded anymore because those have been decriminalized and punishable with penalty now, not fine. So that is the consequence. Any other questions? Yeah. Sorry? No, so this scheme is not available for the companies which have already in process of strike off or there is a winding up procedure ongoing. So this is not available for those. This is available practically for all the companies. If we have to put it in a very simple terms, on MCA master data, companies which are seeing as active, plus active and there is no winding up procedure ongoing, only available, it is available only for those companies. Yeah. No, so liquidation means for liquidation there are two methods, right? If not more, you can do liquidation under Companies Act as well, 271, or you can do it under IBC. So it will take its own course. So you have to. So everything is needed there. But only thing is, for voluntary winding up under Companies Act and even for IBC, once the shareholders pass a resolution for winding up, board is not in effect. All the powers of the board are vested with the insolvency professional. No, there is no third normal winding up than what we have discussed. No, so I think there is some gap. Maybe we can discuss this offline. I'm not very sure what you are asking for really. Anything else? So this is pretty much about it on this scheme. Very straightforward scheme. And another interesting point what they have done in the scheme document is, the last paragraph talks about after the conclusion of the scheme period, that is 15 July, and if we have seen the trend, there are extensions always, but not recognizing that for the time being, if suppose the scheme concludes on 15th July, thereafter the clause says in the scheme that the respective jurisdictional ROCs are instructed shall take actions against such companies who continue to have defaults and who have not taken benefit of this scheme. So we can see some proactive actions being taken from the ROC offices after the scheme is closed. Yeah. Okay. No, so as I said, they will initiate adjudication proceedings and start imposing penalties for those defaults. There will be a course. So they will initiate process. There will be a default of those orders passed. So they will have bigger issues, and also then they will first thing they will do is put the companies for strike off. It will impact on the qualification of those individuals to be directors of the companies, and also they will have exposure on the monetary penalties. Sorry? Yes, yes, yes. Yes, yes, there will be. So what happens is, once the company is struck off, the strike off provisions also say that if whether strike off is voluntary or initiated by ROC, if there are any liabilities that incur after the strike off, the directors of the company, as on the date of strike off, shall be individually, personally liable for those liabilities. So that is the precondition even when you are going for strike off voluntarily. So that's why if we are working on some strike offs, to protect the directors, it is advisable to take that D&O insurance, so that if there is any liability that arises, they are protected at least. Yeah. Yes, sir. Okay, percentage. Okay. So 100 rupees per day, as I said in the beginning, it is not capped. There is no upper cap. Whatever be the, so if suppose additional fee per, as per 100 rupees per day is coming down to 30,000 rupees, then you'll have to pay only 10% of that 3,000 rupees as an additional fee and complete this. Yeah. Normal fee plus this 10% of whatever be the additional fees. Yeah. Anything else? Or this is. So I have got the policies for the clients, but I have never seen a claim coming. So maybe he has got a case where company struck off, but operations are ongoing. They may come across some liabilities. Yeah, right. It's all only about protecting those individuals, right? Because promoters will not be there. The employee individuals are directors, and they to be protected. Yeah. All right. Okay. I think that's about it. Thank you so much.
Any further questions? There are certain announcements. From tomorrow onwards, we are starting with the 3 days intensive course, that is a refreshers course on Income Tax Act 2025. It's free for our BCSE members, and for non-BCSE members, it's 1,500. So today's topic was very simple actually. Just pay 10% of the additional fees and get the matter closed. Only that was the scheme. Now I request Shreyans Dedia to propose a well-deserved vote of thanks.
Thank you, CS Anoop Deshpande, for such an energetic and very live session. He explained with a lot of examples, lot of practical situations. This will help all our members to keep our companies being compliant and take benefit of this scheme. Request all the members to extend a huge round of applause for today's learned speaker. Thank you.
Thank you. So tomorrow, the same venue, 5 to 9.